The special appeal has arisen from a judgment and order of the learned single judge of this court dated 17th November. While allowing the writ petition under Article 226 of the Constitution, the learned single judge set aside an order dated 6th June issued by the Commandant of the 4th Battalion of the PAC at Allahabad dismissing the respondent from service under Rule 4 of the Uttar Pradesh Police Officers of the Subordinate Rank Rules. The punishment was imposed upon the respondent after a regular departmental inquiry into a charge of misconduct. The basis on which the learned single judge has allowed the writ petition is that the respondent, being a Group D employee in the police department, would not, in the view of the single learned judge, be governed by the rules of 1991 applicable to police officer of the subordinate rank, and that the disciplinary proceedings would be governed by the rules framed by the governor under Article 309 of the Constitution, namely the Uttar Pradesh Government Servant Rules 1992. The respondent was appointed on the post of a peon, which is Group D post under the Dyingin-Harness Rules 1947 on 20th May. On 5th June, a charge sheet was issued to him under Rule 14 sub Clause 1 of the Rules of 1991 on the ground of continuous absence with effect from 21st November. The respondent submitted his reply on 22nd June 2013 and 25th June 2013. A disciplinary inquiry was initiated, in the course of which the inquiry officer submitted his report on 15th March 2014. Thereafter, a notice of show cause was issued by the Commandant of the 4th Battalion of the PAC on 6th April 2014, calling him to show cause as to why he should not be dismissed from service under Rule 4 subclause A of the Rules of 1991. The respondent submitted his reply to the notice to show cause on 4th May 2014. An order of dismissal was passed on 16th June 2014. The respondent challenged the order in writ proceedings under Article 226 of the Constitution. The learned single judge allowed the petition on the ground that the service of the respondent were governed not by the rules of 1991 but by the rules of 1999 applicable to the government servants. In taking this view, the learned single judge relied upon a decision of a division bench of this court in Krishna Murari versus State of UP and other 3 decided on 10th April 2012. While allowing the writ petition and setting aside the order of dismissal, the learned single judge granted liberty to the appellants of proceed with the departmental proceedings against the respondent under the rules of 1999 from the stage of the issuance of the charge sheet. A direction was issued to restore the respondent to the status he has occupying when the charge sheet was served together with consequential benefits including reinstatement. The issue which has been raised before the court essentially turns upon the interpretation of the rules which have been framed by the governor.